KPMG, a major accountancy firm, were the auditors for Rothwells Limited. As auditors, KPMG sought legal advice from Mallesons, a major law firm. After the advice was received, the retainer was terminated. Subsequently, the government's Commissioner for Corporate Affairs decided to prosecute a number of senior people from KPMG, including in relation to their work as auditors for Rothwells. They appointed Mallesons as their solicitors. KPMG objected and sued to prevent Mallesons from representing the Commissioner. Mallesons claimed correctly that there was no firm rule against representing a client prosecuting a former client. In any case, they said all of the information they had already obtained from other sources. Justice Ip said, however, that there was a difference between obtaining that information some other way and obtaining information admitted in the secure and trusting atmosphere that prevails when private confidences are exchanged between solicitor and client. So the first point from this case is that confidential information is still confidential, even if it could equally be obtained from some other source. The next issue was the actual test. Sometimes lawyers may act against former clients and sometimes they may not. Where is the boundary? Justice Ip acknowledged that there was no clear test, and so he established one. He said, if, by a solicitor acting for a new client, there is a real and sensible possibility that his interest in advancing the case of the new client might conflict with his duty to keep information given to him by the former client confidential, or to refrain from using that information to the detriment of the former client, then the solicitor may be prevented from acting. This has become the standard test for confidentiality and conflict of interest when acting against a former client. Is there a real and sensible possibility that information given in confidence might end up being used against the former client? Finally, Mallesons argued that they had implemented a Chinese wall or information barrier to protect the information of the former client. This involved isolating some partners of the firm away from the new matter. Justice Ip, however, said that because they were partners in the firm, knowledge held by any one of them could be imputed to all of the others. A Chinese wall could not overcome this. For quite a short judgment, this case provides a number of substantial rulings on the issue of client confidentiality.